Hello again. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on family, property, legacy, taxes, and everything else on my clients' minds. On these episodes, I often talk about some of the more complex aspects of estate planning, things like tax planning for estate tax and gift tax, income tax, GST tax. But I also like to talk about the more basic and foundational issues of estate planning. Sometimes we think about these as like the blocking and tackling, those really important foundational issues for the estate plan. And this is an episode about one of those foundational issues. This is about naming guardians for minor children. For a parent with young children, this is perhaps the most important decision you can make in your estate plan. The guardian is the person who actually raises the child. The guardian has legal custody of the child. They sign permission slips for school. They make decisions at the doctor's office. And the child actually lives in the guardian's home, typically. Clients often struggle with this question of who to name as guardian, and there are lots of reasons for that. Some clients think it's just not that likely, that this provision would only really be needed if both parents are deceased. And many clients recognize this is just a very important and difficult decision. So here are just a few comments as you're thinking about how to name that guardian for a minor child. First of all, you should make this decision. I know it's a difficult decision. I know it's an important decision, but you should make it. Hopefully, you're fortunate enough to have several family members and friends in your life and in your child's life that would want to raise your child if you pass away. But it would be terrible and it would be ironic if upon your death, there's actually a fight over who gets to raise the child and what you would have wanted. Just imagine you might have made comments to friends and family about how you love the way they raise their children, that you would hope they would look after your child if the worst happened. So just imagine that scenario where you haven't spoken, you haven't designated that guardian, and there's a conflict. That's sort of a terrible result. Second, remember that this naming of a guardian isn't really permanent in your estate plan. Here's what I mean by that. The child will change. The child will start to grow up. Consider this spectrum as one example. On one end of the spectrum, you might name a very different guardian for a newborn child. For that newborn child, they haven't made friendships yet. They haven't gotten used to their surroundings. It might not be as big a deal if they move across the country to live with other people. But then think about that child growing. And how about the other end of the spectrum? The child is 17. The child might be a junior or senior in high school, almost an adult. Well, in that case, maybe it's more important of where the child is raised and less important of who they're raised with. So in that case, maybe you wouldn't want to have them go across the country to live with someone else. Maybe it's more important that they live with someone local and finish out high school, or maybe even continue to live in their family's home. So this naming of the guardian will change over time based on the child's age. So again, as you're thinking about who to name as guardian, just maybe take some pressure off yourself. Just think about who would be a good guardian for this stage in the child's lifetime. Another aspect of how this decision will change, the guardian will change. So as an example, some clients like to name their parents, so this would be the grandparents of the minor child, as the guardian. But they're hesitant to do that because they think, well, the grandparents in this case might be aging, getting older. Maybe they're thinking they're in retirement mode. And they think, could they really raise my child for this long time period? But again, this shouldn't be thought of as the one guardian who would be for this, the entirety of the child's childhood. Think about who's the best person to name for this time period, maybe this stage in the child's life. So in that case, if the grandparents are the best decision for the next 5 years or so, I would encourage my clients to name that person and then just revisit it over time. So again, because of the ways that the child will change and the guardians will change, you should just focus on the guardian for the time being. We talk about how important it is to review the estate plan over time, and this is just one example of that. A couple of other thoughts that clients ask about the guardian. Because some clients ask if they should tell the guardian that they've named them. Well, here's my comment. It sort of depends. I know that's a great lawyer answer. I'm always a fan of getting more information if that information will help you make the decision. So just imagine that that guardian that you've named or that you might want to name, is there a reason you need to tell them? So here's an example. Do you think they would say no? Is it possible that they would just say they couldn't take that on? Or is it possible that there's something going on in their life that you don't know about that would mean that they really couldn't serve in that way? Well, if it is likely that they would say no to serve in that role if you pass away, well, that's an important piece of information to know now, and you can plan accordingly. So that might be that might be an example of when you ask the guardian or tell the guardian that you plan to name them. But here's a risk of telling the guardian. Imagine if you change your mind. Well, if you change your mind for any reason of who to name as a guardian, then you might feel obliged to tell that guardian you've changed your mind. Or you might be worried that if you do pass away, there might be a surprise and some tension or disagreement if the guardian is not who they expect it to be. So that could be a difficult situation. So again, that might be a risk of why you might not want to tell or ask the guardian. Some clients also ask if they should name a successor guardian. That's not really necessary from a legal perspective. However, you should just, again, ask those same kinds of questions. What if this guardian isn't able to serve? Do you have a successor in mind? Is there someone who you would feel comfortable raising your children? If so, go ahead and name that successor. If not, if you don't have a successor, then maybe that's just even more incumbent on you to review the estate plan every few years and just make sure the guardian you've named would still be able to serve. Another question that clients ask is, can the guardian serve in other roles? And the answer is yes, as a general matter. The guardian who raises the child could also serve in other roles in your estate plan. A common one might be that the guardian could also serve as the person who manages the child's money. Now, that is a different title and a different role. It might be called the conservator. It might be called guardian of the property. But in these episodes, we talk about that individual as a trustee. So you could have the guardian, the person who raises the child, be the same person who serves as trustee, who manages the child's money. There's lots of efficiencies there. That way the guardian wouldn't have to contact a third party to ask for distributions or to plan for the child's education or the like. But some clients worry about a little bit of a conflict. They might worry that the guardian might act rashly to, buy a new house or double the size of their house. Whereas a third party, if that third party was serving as trustee, might apply the brakes and might be a good sort of a check and a balance to the actions of the guardian. Or another reason you might name a different person is you might just have different people in mind with different skill sets. When you think about the person who's actually going to raise your children, you might think of one person or set of people. But when you think about the skill set of managing money and following the duties of a trustee, you might think of a different skill set. So again, no right or wrong answer here of whether to name the same person as guardian and in these other roles. And here's one other tip. Once the children are adults, consider revising your will to remove the provision for guardianship. Remember that the will is a public document. So upon your death, everybody will see or can see who you named as guardians of your children, even if your children are adults. And this might just lead to hurt feelings of who you chose and didn't choose. So in my view, it's just best to call up the attorney or office, ask them to pull up the old will, remove that article, print out a new one, maybe make a few other changes, and come by and sign. And by the way, this could also be a great opportunity to review that estate plan now that you have adult children. And maybe lastly, consider this as an important first step in the estate planning process for a young parent. Many clients ask me, what are good times for them to think about their estate plan? My initial comment, as I've shared on this podcast, is everyone already has an estate plan. It just might look different at different stages of your life. But when you become a parent, that might be a time to think about a more formal estate plan that would include a last will and testament and other documents that would name individuals to act in these roles. For example, to name as guardian for your minor children. So if you have minor children, consider updating that estate plan. Or if you have family members with minor children, consider encouraging them to at least put that plan in place. And if costs are the barrier, well, there are lots of low-cost options available online, but also you could offer to pay the fees just to remove that obstacle and get this done. I'm Steve Murphy, and this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.